Hi everyone. In this video, I wanted to talk about kind of the draft EA process and sort of where Manoa Banyan Court is, where we are. Um, there's a 30-day comment window that is now open for this project. It closes on January 23rd, so kind of the time is now to make for us, the public, to make our comments. In this video, I'll talk about sort of how we got here, what this kind of means, this window, and towards the end how you can make your comments and why I believe that you should. It's that it's worth it. The time is now. Okay, so just high level, this is from the ERP's website, sort of how we got to this point. So it kind of starts here in the upper left, and this is sort of like the developer maybe thinking, is the significant impact anticipated? And they can try for these exemptions, and if they really believe that there was a significant impact, it would go immediately to down here, which is the EIS, the full environmental impact statement process. But if they um, think that they can get this no significant impact finding, they can go through this DEA or draft the EA process, which is kind of the process that we're in right now. We're kind of in the middle of this. So I'm going to just talk kind of where we are. And again, kind of spoiler alert, we're right here in this 30-day comment period. I wanted to kind of highlight some of these, this assessment process is it's driven almost entirely by this proponent, which is like, the person that or the applicant who wants to do the proposed action. So, they're allowed to consult who they think is a stakeholder, and it's debatable how well they engaged, let's say, the community, but whatever. They prepare the draft EA and submit it. The agency here is DPP for this part, this phase, and this bullet here, or this section 19, is kind of where um, there is an escape down here. If the agency somehow just straight up believed that there would be a significant impact, they could just punt it directly to an EIS. Now, that hasn't happened. It's sort of gone along here, and it's gotten published. And so, there's a lot of questions. How much does DPP really believe that it's no significant impact? And um, it depends on how optimistic you are. For me, I mean, it's like on the draft EA. So my reader here is that the agency DPP really can only look at the draft EA as prepared by the proponent. And this draft EA, it's crafted in a way that sort of wants to show this no significant impact finding. So if you just looked at the document that was given to DPP, it's saying, hey, there's not much going on. And so the I guess it's not like the document alone, the draftee alone, is enough for the agency, in this case DPP, to just say, okay, it's significant. Um, and that's kind of I believe that's why it's here. It's being published, not necessarily from what DPP sees so far in this document, the document saying that it's no significant impact, the FONSI finding of no significant impact. But after the comment period, which is what we're in right now, and it's going to close the 23rd of January. So we have a 30-day window opened 2 days before Christmas. And after this comment period, then the proponent, so in this case the LYCA, has to sort of incorporate these comments. So they do need to respond to these comments that we give. Um, and at that point, the agency, the DPP, will then make that determination of whether it is significant impact or not. So um, I guess my read on this is that, from what DPP sees so far in the document, the document saying that there's no impact, here we are right now, and the public is now, able to provide their comments. And, hopefully, right, if the comments are substantive, then it would be incorporated into the final EA, and DPP will then be allowed to make a determination based on the the EA after all of these incorporated public comments. And at that point, they would make the determination whether or not it's going to be actually the no significant impact, or if it's going to go down to the EIS. Um, EISPN is the preparation notice, so that's the kind of document that will kick off the full EIS process. So kind of a summary, kind of what it is and what it isn't. The DEA, it's it's written solely by the proponent, right? The proposed developer, and they're allowed to sort of craft it, right, in the way that of their choosing. Um, and they are kind of incentivized, right, to say that there's no significant impact because that means that they don't have to do the EIS and it can continue, right? The proposed action can just continue. Um, so I guess my takeaway here is that you know it's just an assessment by essentially by the proponent. It's not really objective per se, and there's nothing saying that it needs to be. Like there's nothing in here that says you know that the proponent has some fiduciary responsibility or something to the public where it needs to be um, like fully comprehensive and all, and part of that, so that's where I feel like the public or we can come in. We're sort of the checks and balances in this process, right? This is where it opens up. Right now it's opened up to everyone to kind of draw attention to certain points if the DEA is lacking, or to provide maybe it either was not comprehensive, or it it phrased it kind of in a one-sided way. Um, and this is where we can kind of provide inputs that hopefully will create a more complete picture that then the agency, in this case DPP, can render a determination that's maybe more fair. I don't know. Okay, so I wanted to just show some of the. This is this is how it starts. This is how, if you clicked on that link for the DEA publishing, it's this first thing where uh, DPP is telling ERP to publish. And to do that, based on that block diagram, it needs to have this anticipated finding of no significant impact. So if it wasn't anticipated, it would have taken that escape that you saw down directly to the EIS. So to get published, it needs to sort of be in this state where they're saying that kind of the draft EA is stating no significant impact. I don't, I didn't like this phrasing that they used. Um, they're saying, in this text that DPP have considered every phase, expected impacts, mitigation, and we anticipate a finding of no significant impact. So it makes it sound like they did, they went above and beyond what the draftee presented to them. I'm not sure if that's true. I just want to share for context. I don't want people to read this and just give up, thinking that, well, it's a done deal. This is the letter that DPP will send, in this case, to a neighborhood board, because the Manoa neighborhood board is like what they consider a participant. Like they're asking for input from the Manoa neighborhood board in this case. In this letter, I think, I believe this phrasing, I like it better. Based on the information currently available, DPP anticipates this no significant impact finding. So I feel this is a little bit more clear. Uh, it's saying that, hey, given the DEA as presented to us by the proponent, based on that information kind of so far that we got, we're gonna anticipate this no significant impact. We're gonna kind of go along with this document, and um, yeah. So I guess the point here I wanted to make is that I think it's the time to act is now. I don't think it's a done deal. DPP hasn't issued their kind of official determination. That happens after the public comment and the comments get incorporated into the final EA.